Well, good morning, everyone, and thank you for your patience. It seems to be a combination of user error and technical difficulties at our end. So thank you for your patience. I think we are sorted now. Just to welcome you to today's webinar, Discrimination Update, Managing Gender Identity Issues. We do just have a little bit of housekeeping before we begin. Now, for some reason, I can see the chat box, I can see your questions, but for some reason it seems that the chat box has been disabled. So please continue to put your questions into the Q&A because I can see them, and I will attempt to answer those at the very end. Okay. If you have any experience with audio difficulties, please also let me know through that box, and we will do what we can at this end. And of course, as always, please note the information in this webinar is intended for teaching and information purposes only and is in no way legal advice. If you do require legal advice, please contact our office on 1300 862 529. All right, so the plan for today. Today we're going to work through some language, just so that we're all speaking the legal language around these issues, an overview of discrimination law and an update as to what's changed and what's coming, as well as deal with some specific issues. The disclaimer is here again, and because this presentation is not legal advice, please do always feel free to contact our office, particularly since discrimination law can be state by state. All right. Definitions and concepts. So let's dive in. So it's important to familiarise yourself with some of the language around these issues, because it's important to be able to speak respectfully about these concepts and have a respectful understanding. But more than that, well, as well as that, I should say, it's important to have a good understanding of what we're talking about, because these are all words that are used at law. And so without a good understanding, I guess, of what we're talking about, the church will have difficulty navigating its legal responsibilities. Now, some of these words will have legal definitions as well, as set out in various acts, and there are specific definitions in different acts, but just by way of a general introduction and as a general guide, when we're talking about gender, we're referring to the way in which a person identifies or expresses their masculine or feminine characteristics. So a person's gender identity or gender expression is not always exclusively male or female and may change over time. Now that's the position at law. In terms of gender expression, this refers to the way in which a person externally expresses their gender or how they're perceived by others. And gender identity is more internal. It refers to a person's deeply held internal and individual feeling of gender. The term cisgender refers to people who identify their gender in the same way as was legally assigned to them at birth. Sex characteristics refers to a person's primary and secondary sex characteristics, chromosomes, hormones, reproductive organs, genitals, that sort of thing. And sexual orientation refers in a general sense to a person's romantic or sexual attraction to another person, and might be described as heterosexual, gay, lesbian, bisexual, pansexual, asexual, or same-sex attracted. As a general guide, endosex refers to people whose sex characteristics meet medical and social norms for typically male or female bodies, whereas intersex refers to people who are born with genetic, hormonal, or physical sex characteristics that do not conform to medical norms for male or female bodies. Intersex people have a diversity of bodies and identities. And the term transgender is essentially an umbrella term for people whose gender identity is different to that which was legally assigned to them at birth. So I realise that's quite a long list of definitions, and there might be some terms there that are new or confusing. These things are being more and more I guess, defined and discussed at law. So as I say, it's important to be familiar with them, not only so that you can have respectful conversations around these issues, but to ensure that you know what your legal obligations are. So understanding discrimination law. Now, if you were with me a couple of years back listening to a similar presentation, you might recall me saying that there were some significant changes coming to the Anti-Discrimination Act, and this was the slide that I used. However, that has all been put on pause, and we'll come to that more in this seminar. So we'll just move on to talk about what discrimination law is. So there are laws in each state and territory, as well as at the federal level, which prohibit discriminating against a person on the basis of gender identity or sex, amongst other things. So, for example, in Queensland, discrimination on the basis of gender identity, lawful sexual activity, sexuality, sex characteristics is prohibited by the Anti-Discrimination Act, which is a state act. But as well, people living in Queensland are covered by the Sex Discrimination Act, which prohibits discrimination on the basis of sex, sexual orientation, gender identity, and intersex status. So we have these two sort of regimes operating. There is the state-based laws and there are the federal-based laws, and you're required to comply with both of them. There's a lot of overlap and a lot of similarities, but there are also some points of difference. So each state and territory has enacted anti-discrimination legislation, which means individuals who say they have been discriminated against can lodge complaints at the state territory level or at the Commonwealth level, depending upon the circumstances of the complaint. So you need to understand that the discrimination laws in your state, the laws in your state, as well as the federal laws, so that you don't engage in an act of discrimination. And it means for a national movement, churches in different states might be needing to comply with slightly different state laws in this regard. So in Queensland, when we're talking about gender identity, we're talking about the person's internal and individual experience of gender, whether or not it corresponds with the sex assigned to that person at birth, and without limitation includes the person's personal sense of their body, and, if freely chosen, modifications of their bodily appearance or functions by medical, surgical or other means. And it also includes other expressions of the person's gender, for example, their name, their dress, their speech and their behaviour. You can compare that to the definition of gender identity in the Sex Discrimination Act, which means the gender-related identity, appearance or mannerisms or other gender-related characteristics of a person, whether by way of medical intervention or not, and with or without regard to the person's designated sex at birth. So as you see, there's a lot of overlap there and a lot of similarity. Just to give you an example of the definitions in other places, I have included a slide on that, but I won't labour that given most of our participants today are from Queensland. Okay, so what is discrimination? Well, at a state level in Queensland, discrimination is prohibited on the basis of these attributes, and they're listed there from the Anti-Discrimination Act. So you'll see there's sex, relationship status, gender identity, sexuality, sex characteristics, and this is why I say it's important to have a good understanding of the different language and terms that are used so that you can be respectful but also comply with your legal obligations. In all jurisdictions, discrimination can be direct or indirect, and under the Queensland Act, discrimination on the basis of an attribute can be direct or indirect and includes discrimination on the basis of a characteristic or something that is typical of a person who has the attribute, generally has that characteristic. A characteristic that is often imputed to a person who has the attribute. So a characteristic that is often imputed to a person of a particular gender identity. An attribute that a person is presumed to have or to have had at any time. Or an attribute that a person had, even if it did not have it at the time of discrimination. Now, there has been a bill introduced in Queensland just in the last month, really, to amend some of these definitions, but we'll come to that later in the presentation. So, what is direct discrimination? Direct discrimination, and again, we're talking at the state level here, on the basis of an attribute, happens if a person treats or proposes to treat a person with an attribute less favourably than another person without the attribute would be treated in circumstances that are the same or not that different. So essentially what it means is there's a comparison going on. So if someone has an attribute, such as the fact that they are transgender, then it would be discrimination if you propose to treat them differently than you would treat another person who's not transgender in circumstances that are the same or not materially different. And it's not necessary that the person who's discriminating considers the treatment to be less favourable and their motive for discriminating is irrelevant. It's just whether it happens or not. So, for example, of direct discrimination, transgender people cannot use the toilets that correspond to their expressed gender identity. Now, there are some exceptions, and we will get to those, but this is the starting point for considering direct discrimination. There is an attribute, and the question is whether there is discrimination based on that attribute or because of that attribute. So indirect discrimination on the basis of an attribute happens if a person imposes or proposes to impose a term with which the person who has the attribute can't comply, or they're not able to comply for some reason, with which a higher proportion of people without the attribute can comply, and the proposed term is not reasonable. I realise that's a lot of words, and if you feel like your head's going in circles just at the moment, that's quite common, and it is something to get your head around. But to give an example, it will be indirect discrimination if the church imposes a requirement or practice, for example, that transgender people can't comply with which only people who are not transgender can comply with, and is not reasonable. And it's that reasonable point that we'll talk about later with the exceptions. By way of giving you some more examples to get your head around this difficult concept of indirect discrimination, a church decides that only people who are over 190 centimetres tall may become pastors, although their height is not relevant to their religious beliefs or practices. This disadvantages women and people of Asian origin because there are more men of non-Asian origin who can comply with this requirement. The height requirement is unreasonable. There's no genuine reason to justify it. Now, again, there might be some exceptions, but that's the kind of mental gymnastics that happens when you're considering indirect discrimination. A more straightforward example, an employer requires employees to wear a uniform, including a cap, for appearance reasons, not for hygiene or safety reasons. This requirement is not directly discriminatory because it applies to everyone, but it has a discriminatory effect against people who are required by religious or cultural beliefs to wear a particular headdress. So in terms of the exceptions, there are certain exceptions. Again, we're talking about the Queensland Anti-Discrimination Act at this point. There are certain exemptions that apply. The Act does not apply to a religious body in the following areas: the ordination or appointment of priests, ministers of religion, or members of a religious order, the training or education of people seeking out ordination as priests, ministers of religion, or members of a religious order, the selection or appointment of people to perform functions in relation to or otherwise participate in any religious observance or practice. And unless Section 90 applies an act established by a body established for religious purposes, if the act is in accordance with the doctrine of the religion concerned and is necessary to avoid offending the religious sensitivities. Sorry, they're the exceptions there. So what is a religious body? It's not defined in the Queensland Act. It may be defined in other states. But in Queensland, what is talked about is religious activity and religious belief, and they are defined in the Act as meaning engaging in or not engaging in or refusing to engage in a lawful religious activity. And what is a religious belief? It means holding or not holding a religious belief. So whether an exemption applies to a particular activity may depend on which state the church is located in, even where the denomination is national and has a national statement of faith. So in Queensland, any discriminatory action taken by a religious body will be exempt if the act is in accordance with the church's doctrine and is necessary to avoid offending the religious sensitivities of people in the religion. But whether it's a religious body is usually not the problem. The complexity is usually around the particular, the religious activity or the belief. It's important not to assume that the act is in accordance with the church's doctrine just because it's an act done in connection with the church. And don't assume that it's a simple assessment or a matter of simple opinion as to whether it needs to be done to avoid offending the religious sensitivities of people of the religion. This has been worked out or worked through in some states to some extent in the courts, but not in Queensland. It's really important to get legal advice if you're looking to engage in an act of discrimination based on gender or sex or sexuality, because it's really going to turn on whether the activity is captured by the provisions of the Act and whether it is necessary to avoid offending religious sensitivities, which might be narrower than you might expect. So there was a case delivered by the Victorian Court of Appeal which states that the word necessary means that there must be no alternative to engaging in the discriminatory conduct if injury and religious sensitivities, which is the wording in the Victorian legislation, was to be avoided. And that case involved a resort owned by the church, which could be rented by the public for their camps and events. The church did not want to rent the premises to a group which supported homosexual young people. And in that case, the court said adherence to a religious belief in abstaining from all sex other than married heterosexual sex did not require a person to actively persuade others to the same practice, nor to actively condemn all other sexual practices and gender expressions. In this case, the religious body could hold their belief and personally express that belief that sex should be between married heterosexual couples, and they did not have to actively prevent others. So the resort should be available to the group in the same way that the resort is available to everyone else. The court also commented that if the resort was in any real sense church premises, this would have supported the claim of an exemption on the basis of religious susceptibilities, because it is reasonable for adherents to a religion to be able to insist that their places of religious observance be used for and only for the propagation of doctrines and principles to which they subscribe. So there has been some exploration of the concepts, but as I say, they are interstate, and it is a thing to be worked through if you find yourself in the position of asking a question about discrimination. So there were previous amendments proposed to the Anti-Discrimination Act, which were due to commence mid last year, but this has not eventuated. They were put on hold. The commencement was put on hold. There was further public consultation that ensued. But what we have very recently is the introduction of a bill called Strengthening Protections for Queensland Workers Amendment Bill 2026. And the focus in this bill is not just on equality of opportunity, but on equitable outcomes. The bill introduces new attributes and updates definitions of some existing attributes. So, for example, there's a new attribute of irrelevant medical record and sexual orientation to be included rather than the word sexuality as an attribute. And sexual orientation would be defined as the person's capacity or lack of capacity for emotional, affectional, and sexual attraction to, or intimate or sexual relations with, persons of a different gender or the same gender or more than one gender. The bill amends the definition of discrimination. Sorry, here, catch you up. Amends the definition of discrimination to remove the need for a comparator. So all those mental gymnastics that we were doing earlier to work out, who we've got to compare this situation to determine if discrimination has occurred, has been significantly or is significantly simplified in the proposed amendments, and it's more along the lines of has there been harm caused or an unfavourable outcome reached. It remains to be seen whether this bill goes through, so we're not going to spend too much time on it today, but just to flag it as something that is to be watched and travelling through. And amendments to vilification provisions in the Anti-Discrimination Act. So updating and expanding the list of protected attributes for both criminal and civil vilification to include, among other things, sex, gender identity, and sex characteristics. The proposed amendments clarify the test for civil vilification such that it does not require the complainant to show that another person actually did incite hatred, serious contempt, or severe ridicule of them because of their protected attribute, but that the public act was likely to incite those things. So they are significant proposed changes, but again, it remains to be seen what happens with that bill. So remember I said at the beginning that discrimination legislation operates in two jurisdictions. You've got the state provisions. You've also got the federal Sex Discrimination Act, which prohibits discrimination on a range of grounds, including on the ground of sexual orientation. So you'll see there the definition set out. For the purpose of the Federal Act, a person will discriminate against another person on the ground of the aggrieved sexual orientation if, by reason of their sexual orientation or a characteristic that pertains generally to persons who have that sexual orientation or is generally imputed, they treat the person less favourably in circumstances that are the same or not materially different than you would treat a person who has a different sexual orientation. And again, we've got provisions around indirect discrimination as well. So it would be discrimination under that Act to impose a condition, a requirement, or a practice that has or is likely to have the effect of disadvantaging persons who have the same sexual orientation as the aggrieved person. And again, it means that the condition, requirement, practice will be exempt if it's reasonable in the circumstances or a part of special measures taken for the purpose of achieving equality. There is an exception under the Federal Act, the Sex Discrimination Act, and it relates to religious bodies. It doesn't define a body established for religious purposes, but religious bodies will not be in breach of the discrimination provisions in relation to the ordination or appointment of priests, ministers of religion, members of any religious order, training. So you'll see there's some commonality here with the Queensland Act. The selection or appointment of persons to perform duties or functions for the purpose of or in connection with religious observance or practice, and any other act or practice of a religious body being an act or practice that conforms to the doctrines, tenets, or beliefs of that religion necessary to avoid injury to the religious susceptibilities of adherents to that religion. But essentially, that won't apply if you provide Commonwealth-funded aged care services. So you might have seen in the news and have some questions about a recent case called Giggle for Girls Proprietary Limited and Tickle, which was an appeal case which was handed down just very recently this year. So in the full federal court handed down what would have to be described as a landmark decision on when a person will be found to have directly discriminated against someone on the basis of their gender identity under the Sex Discrimination Act. So Giggle for Girls Proprietary Limited was a social networking app that was marketed as a digital women-only safe space. To verify a user's sex, Giggle relied on facial recognition software, which purported to assess a user's physical characteristics to determine if they were a cisgendered female or appeared to have the physical characteristics of a cisgendered female. And Giggle determined that Ms. Tickle did not possess the physical characteristics of a cisgendered female, leading to her being denied the use of and eventually denied access to the app. So at first instance, the federal court found that Giggle and its CEO indirectly discriminated against Ms. Tickle on the basis of her gender identity because it imposed a condition on using the app that excluded all people who were of male sex at birth. And this included transgender women who possessed the physical characteristics that the app defined as not those of a cisgendered female. And so the condition had the effect, or the condition or the term, sorry, had the effect of disadvantaging transgender women who did not meet that condition. But on appeal, Giggle alleged there was no unlawful discrimination under the Sex Discrimination Act. They submitted that the decision at first instance was incorrect to define sex for the purposes of the Sex Discrimination Act as not being a purely binary concept, and also erred in not finding that the imposed condition was reasonable, and therefore it couldn't be indirect discrimination. Ms. Tickle cross-appealed and said that her exclusion from the app constituted direct discrimination. The damages were inadequate and the overall outcome was manifestly inadequate, including by reference to the general standards prevailing in the community. And ultimately, the court made orders that Giggle and its CEO had directly discriminated against Ms. Tiggle in the provision of goods and services by excluding Ms. Tickle from accessing the app on the basis of gender-related appearance, refusing to restore her access on the basis of gender-related appearance, and treating Ms. Tickle less favourably than a person designated as female at birth in seeking access to the app. So increased the damages payable and had to pay legal costs. So one of the key takeaways from that is that the comparator for a transgender woman in a gender identity discrimination claim under that part of the Sex Discrimination Act is a cisgendered female. Now, of course, the exemption at Section 37 was not considered in the Act, but it is an interesting development. It's a significant development in the interpretation of the Act, and a case that will continue to be watched. There is an expectation, I think, that it might proceed further and that we might get a High Court consideration of the matter, but that is certainly something that we're watching and is not guaranteed, and that's the law as it currently stands. So just to give you a case study, which is made up, by the way. It's made up, but I just wanted to give you something sort of more concrete to sort of think through some of the issues that you might be facing. So Charles has grown up in the For Example Church and has been very involved in different ministries for years. His father is a deacon, and at age 19 comes to the realisation that his gender identity is female and he now wishes to express himself that way. He does not want to engage in a medical transition, but intends to present as female in the way he dresses and speaks and go by the name of Sarah. Sarah would also like to use the female bathrooms at church and maintain involvement in leading worship on Sundays. How does the church respond? So there are lots of things that you would have to think through. The fact that it's located in the church, whether there are any exemptions that apply, what are the beliefs and doctrines and tenets of the faith, and how are they presented? And it's a fairly complex question at law. The kinds of things that we might be thinking about is, does the statement of faith adequately address church beliefs in relation to all the different concepts identified at law? I, in my work, will often see statements of faith that simply says we only recognise maleness, femaleness, masculinity, femininity. But the church really needs to think through, well, that may very well be our position. The law recognises these other things. How do we respond to that? And think that one through. A key question will be, are the doctrines, tenets and beliefs of the church clearly identified and consistently adhered to? Is it a requirement for volunteers to sign a volunteer agreement, which requires them to agree with the statement of faith and set out codes of conduct which align with the doctrines and beliefs of the church? Does the church rely on volunteers, which is essentially what Sarah would be, to do activities that involve the spread or strengthening of spiritual teaching, the maintenance of the doctrines of the church, or the observances that promote or manifest the doctrines? Because if you discriminate in relation to volunteers, in some of those ways, that's going to have an impact on your response. Where do the church activities occur? And what else needs to be considered? So there are issues in relation to privacy, duty of care, etc. But even if we could come to the conclusion that an exemption applied, it's still important that to know that the church cannot engage in vilification of gender fluid persons or vilification of any person on the basis of an attribute. So even if the exemption to discrimination applies in this particular case study that we were just looking at, a church based in Queensland must still not engage in unlawful vilification nor serious vilification of transgender persons in their churches. So unlawful vilification means a public act that incites hatred towards, severe ridicule of, or serious contempt for a person or group because of their gender identity or sexuality. It has to be a public act capable of inciting those things. And as I said earlier, this is one of the provisions of the Anti-Discrimination Act that is proposed to be amended so that it makes clear that it doesn't require that hatred or serious contempt has occurred, but just that the conduct is likely to. Public act will also, or has been proposed to be defined as including things that occur in private spaces, particularly around online conduct. So the provisions may impact significantly, proposed provisions may impact significantly on this part of the Anti-Discrimination Act. And even if an exemption applies, you can't engage in any gender change or suppression practices. Legislation banning conversion practices has been passed in the states listed there. In Queensland, there's a ban on conversion practices in health settings. In Queensland, it's sort of an open question. The church may have obligations towards transgender individuals pursuant to the Public Health Act. This would include, for example, attempting to change a person's sexual orientation or gender identity using shame or coercion to give them an aversion to same-sex attractions or to encourage gender-conforming behaviour. It also likely includes using any techniques to encourage them to believe that being transgender is a defect or a disorder. That will apply in circumstances where the church offers a service which is captured by the meaning of health service in the Health Ombudsman Act, psychologists, counsellors, social workers. So that's just an important point to note. But care should be taken to ensure that sermons, prayers and pastoral care cannot be perceived to be counselling or conversion practices in disguise. Okay, well, I think that brings us to the end of the webinar. Again, my apologies for the technical difficulties at the beginning. Very frustrating for all of you, I'm sure. If you have any further questions, as I say, please feel free to contact myself on the email address provided. Whoops. eustacia.yates@vocarelaw.com.au. You can find me on Vocare Law's website. That's VOCARELAW. You're very welcome. And for upcoming webinars, you can also head to our website, www.vocarelaw.com.au, to register, showing my age there. A copy of the PDF slides will be made available in 24 hours on our website, and we look forward to hosting you in the future. Thank you very much.